It's been a while. I haven't put out a video in almost 2 weeks. Well, I came across this tweet today and it reminded me that I was going to do a video on all the sniveling and crying over Judge Schroeder's rulings in the Kyle Rittenhouse case. Here's a pretty good one. So let me read this. Now, I have to put this in the proper context, right? Okay, so we're going to need some sound effects here. So here we go. This is by Lisa. Her Twitter handle is at Jane57Lisa. Okay. Are you ready? Okay. The performance by the judge was the most inappropriate and despicable ever. I could not believe what I was seeing and hearing. It was outrageous. He decided before the trial began that he was going to make sure Kyle was acquitted. This guy. Yeah, we know who Judge Schroeder is. We're going to talk about his responses to the motions by Thomas Claire Vinger in this video. Hello out there. I am trying to get
With his
through.
powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
All right, let's talk about these motions that were filed by Thomas Claire Binger that Judge Schroeder basically batted out of the ballpark and which has incited so much rage into the anti-Kyles. And let's start off with number one. Can't use the word victim. What is amazing about this motion by Thomas Claire Binger, that he be allowed to use the word victim during the trial, is that he knew ahead of time that the judge was not going to rule in his favor. There is no chance in hell that Judge Schroeder, who had a long-standing practice of not allowing the word victim to be used in trials, was going to change his mind. And in fact, if he had, the appeals court might have used that against him. I mean, they could have said it was a long-standing practice by you to not allow use of the word victim, and you changed it for this particular trial. It sounds like you were prejudicing the jury against the defendant. And so Binger knew he had no chance of winning this one, and he didn't care. I mean, this is the one where people thought, oh, Binger got screwed. No, Binger knew he wasn't going to win it, but he wanted to put that out there because it would enrage the public, who, because a lot of them are anti-Kyles and therefore dumber than dog snot, would never understand why the judge would not allow the people that Kyle shot to be called victims. But anybody who understands the law knew that it was a perfectly reasonable ruling on part of the judge. Yes, in a regular murder trial, it may not make much difference. And the reason is very simple. During a regular murder trial, there's usually, not always, but there's usually no misunderstanding that the person who was shot is a victim of a crime. The issue is who did it. And therefore, the defense doesn't really care if the decedent is labeled a victim or not. However, in a self-defense trial, it's completely different. In a self-defense trial, the accused has to admit that they shot the person. Therefore, calling that person a victim implies that they're a victim of crime, and therefore, who else could it be other than the person accused of it? Allowing Kyle Rittenhouse's shootees to be called victims provided no probative value whatsoever. None. It did not help lead the jury to decide whether Kyle Rittenhouse shot in self-defense or not. But the prejudicial impact was pretty high. It would imply that Kyle was guilty of a crime. Therefore, it's a no-brainer to not allow use of the word victim in a self-defense trial, and no judge should. There was another trial that took place afterwards. It was in Wisconsin as well. I'm trying to remember the name of that judge did allow use of the word victim in his court. In my opinion, that was a mistake. However, different judge. Every judge is different. As long as Judge Schroeder always ruled that you could not use the word victim in a self-defense trial, so Suck it up, buttercups, tough noogies. The judge was perfectly in his rights to not allow use of the word victim during the Kyle Rittenhouse trial. Okay, that brings us to number 2. So the motion was that if you're not going to allow Kyle to be called a victim, well, then you can't allow Gage Grosskreutz and Anthony Huber and JoJo Rosenbaum to be called arsonists or looters or anything like that. But that's absurd. There's no reason why one has anything to do with the other. Let I remind everybody that Kyle Rittenhouse is the accused, not a witness. The accused is entitled to far more protections than a witness. Now, if Gage Grosskreutz, for example, was being tried for arson, then he would not be allowed to be called an arsonist because he is then the accused and they're entitled to certain protections. As a witness, they are not. And keep in mind, the judge never said that the defense could call these people arsonists and looters and whatever. He just said he might allow it depending on whether the defense had shown that they were in fact arsonists or looters or whatever. And now I know some people are saying, well, that shouldn't matter, but it does. If I'm claiming self-defense and there is overwhelming evidence that the person I shot was intruding into my house to burglarize it, I would hope that I would be allowed to call the victim, okay, here we go, a burglar. Because after all, it's your defense. If you don't allow that person to be called a burglar, then you're taking away an important part of the defense's argument as to why the shooting was justified. We give the accused a lot of leeway in these matters. So allowing Gage and his buddies to be called arsonists, looters, and whatever, it's misunderstood. He didn't say that you really could, but it was a perfectly reasonable ruling. Sorry, but that's just the way it is. Okay, that brings us to another one. Can't say that Kyle used stimulus money to buy the gun. This may be the stupidest motion that I've heard in a long time. Thomas Clarebinger wanted to introduce to the jury that Kyle used stimulus money to buy the gun. Of what possible relevance, I have no idea. Thomas Clarebinger never really explained it well, and the judge basically just said, oh, give me a break. It was so preposterous that Thomas Clarebinger was willing to drop the whole thing about it being a stimulus check, right? Well, you have to pay for the gun somehow, so is your emotion really nothing more than just saying that Kyle used money to buy the gun? I don't know. This is another example where I think that Thomas Clarebinger knew that the judge would not allow it, but he wanted to get out into the public that Kyle used stimulus money to buy his gun. Who cares? It doesn't matter. The source of the money, unless Kyle robbed a liquor store, wouldn't have any effect. And in fact, even if he had robbed a liquor store, it wouldn't have mattered. The source of the money to buy the gun was completely irrelevant to anything. How would it help the jury decide whether Kyle acted in self-defense or not? I challenge anybody to come up with any logical explanation for that. All right, we go to can't play the CVS video. Now, this is one where I thought might have a chance of actually getting entered in as evidence, because at the time that it was introduced, I didn't know what the Sullivan case was. But after reading the Sullivan case, it was pretty obvious that this was not going to be allowed. So Kyle is sitting in a car and they're watching some looters in Chicago, and Kyle said, man, I wished I had my gun. I would shoot them, or something like that, right? Now, first of all, who in the hell here hasn't said stupid things like that? I've said it many times, and they're like, hey, if I was in that pickup truck, I would just mow those protesters down. But I wouldn't actually do it. I mean, come on. People say all kinds of tough guy stuff that they never actually mean. And so to convict somebody based on a tough guy talk that he made 2 weeks prior would have been beyond lunacy. Okay. Ultimately, the judge ruled that, look, if he had been chased by these looters and then turned around and shot them, that might mean something. But nothing that happened in Kenosha resembled anything like that on the video. Now, Binger tried to claim, well, it shows mens rea. It shows that there was a state of mind that Kyle had. No, a state of mind is something that you might have minutes or maybe an hour prior to a criminal act, not 2 weeks later, and it was 15 days later. If you have that kind of state of mind that lingers for 15 days, then that's actually a part of your character, and character evidence is not admissible. It becomes propensity evidence. And ultimately, the judge decided that this is propensity evidence. Despite all your wranglings, you're really just trying to show that Kyle is the kind of person that would shoot people because he claimed he would earlier. But you cannot allow that in a court. Not in Wisconsin, maybe in some states, but in Wisconsin, nope. Propensity evidence is not admissible. Essentially, you can't try somebody based on the fact that you think he's the kind of person that would do that kind of act. You can't convict somebody just because you think that he's the kind of person that would do something like that. If you did, people who have criminal records would just simply be convicted over and over again, because every time that the person was accused of a crime, they would just bring back his past criminal convictions and say, you see, he's robbed before. It must have been him because he's the kind of person that likes to rob. We don't do that in this country. Now, maybe in some countries they do, but not in the United States. Now, there is this Sullivan test, and the judge never even bothered to apply it because the motion was so stupid. However, if the judge had bothered to apply it, it would also have been ruled inadmissible. Why is that? Well, the Sullivan test came about from a domestic violence charge that happened some years ago. And a person was accused of assaulting a woman, and he had threatened his previous girlfriend, or maybe wife or whatever, some years before to kill her. And the question became, well, can you admit that evidence? And the Sullivan test said no. Why? Simply saying that you are going to do something cannot be used later to show that you did. Not if it's to a different person. Now, if he had threatened the same person prior, maybe. But again, this is the test for propensity evidence. And if you can't admit evidence that a person had threatened somebody prior with the same kind of offense, domestic violence, then you're certainly not going to allow Kyle's comments about shooting looters to be included in a murder trial. So even if the judge had applied the Sullivan test, it would have still been ruled inadmissible, and the judge knew it. He's not going to allow it because any appeals court would have slapped that one right back. Are you kidding me? And Judge Schroeder probably doesn't like being overruled by an appeals court. So Can't Play That CVS video was actually perfectly rational. It aligned with courtroom procedure and the law. There's no denying it. And anybody that disagrees can read the Sullivan test and they would see that, yeah, okay, yeah, I can understand why the judge ruled the way he did. Or they won't, because we're talking about anti-Kyles here. And they'll just simply refuse to read it. I mean, if you say, hey, look, here's a video that shows you why that evidence was ruled inadmissible, they would refuse to watch it. And how do I know that? I'm on Twitter all the time where I show them the evidence, and they almost 99% of the time simply refuse to watch it or read it because they're afraid of what it might say. Oh, here we go. Can't show Kyle with the Proud Boys. This is one where the hypocrisy is intense. Kyle is essentially being accused of being in a gang that takes part in criminal activities, right? I mean, the gang is the Proud Boys. And as Judge Schroeder ruled, look, even if Kyle was a member of the Crips, accused of, say, selling drugs, you still couldn't use his membership in the Crips as evidence. Essentially, just because you belong to a gang doesn't incriminate you in any crimes that other members of the gang might engage in. Of course, there's even bigger problems for this one. Kyle wasn't a member of the Proud Boys. And in fact, Kyle didn't seem to have any affiliation with the Proud Boys at all. So that makes it really hard. I mean, if you're going to accuse Kyle of murdering because he's a member of the Proud Boys, you better show that he's a member of the Proud Boys. Or you can show that he had an affiliation with the Proud Boys and that compelled him to engage in whatever he did, but there's no evidence of that either. And in fact, Thomas Clare Binger admitted he had no evidence that Kyle was a member of the Proud Boys that night in Kenosha or had any affiliation with them whatsoever. Now you may be wondering, well, didn't Thomas Clare Binger know that the judge was going to slap this one out of the park? Yes, he did. He brought this one up because this is perfect propaganda. I mean, Thomas Clare Binger is not a particularly great lawyer. However, he is a great propagandist. He knows how to play the public, and he did this on purpose. He knew that the public would go all ape shit over the fact that Judge Schroeder would not allow the Pudgy's Tavern incident in as evidence. But anybody who studied the law knew that that Judge Schroeder was not going to allow it. He couldn't allow it. And if he had allowed it, the appeals court would have overturned any conviction, which Judge Schroeder basically said. The crazy thing about it is that this rule that doesn't allow you to use gang membership as evidence benefits people of color more than white people. Unless you're talking about Irish gangs or Russian gangs, most of your gangs are people of color. And therefore, they get accused of crimes more often than white gang members. And therefore, this ruling benefits them more than anybody else. So it's not a racist ruling at all. So the can't show Kyle with the Proud Boys. Well, guess what? Perfectly reasonable ruling on that. Aligned perfectly with the rules of evidence admissibility. Sorry. That's the way it is. That's the way the law was. The fact, by the way, that this incident with the Proud Boys took place 4 months later was also huge. If it had occurred 2 days later, maybe no, not even then. You still have to show that he was a member of the Proud Boys that night. So give it up. Can't show hitting a girl. Well, okay. There are a number of problems with this motion. Number one, we don't even know what the fight was about. We know so little about it. We don't know who was in the right or the wrong. There's no police report. So how can you claim that this is evidence against Kyle Rittenhouse when we really don't even know what happened? Thomas Clare Binger, in his motion, claimed that this shows that Kyle Rittenhouse enters matters that do not involve him. Well, how do we know that it didn't involve him? How do we know that the fight wasn't about him? Who knows, right? Of course, the bigger problem with this one was that simply getting into a fight with somebody 2 weeks prior, a fist fight, doesn't tell you whether the person acted in self-defense using a rifle 2 weeks later. I mean, that's just insane. I don't even think that Thomas Clare Binger figured that this one would get past Judge Schroeder. So why did he enter it? Well, if you read the motion, you'll notice he mentions a female victim all the time. Throughout the entire motion, he's always talking about the victim in this case, and whatever, I don't know if she's a victim or not, but whatever, that she is a female. Even Thomas Clare Binger knew that this was not evidence to be used in a murder trial. He wanted to get this thing out there so he could remind the public over and over that Kyle hit a girl. And it's really strange that the judge never picked up on this. But when you read it, it's pretty clear that Thomas Clare Binger is just wanting to reinforce that Kyle hit a woman. And by the way, these shootings in Kenosha had nothing to do with that. Kyle never shot any women. Now, if, for example, Kyle was accused of picking out women to shoot, then this might have been used. Probably not. But it at least would have been somewhat reasonable. However, in this case, the footage of Kyle hitting that woman or girl on the side of Lake Michigan there, inadmissible. It wasn't even close. So that brings us to the next one. The judge Drop the gun charge. Well, we've been through this a million times. Look, everybody, the judge dropped the gun charge because he had to. Let's face it, if you read the statutes carefully and you absorb them, you'll start to come to a very clear understanding that nowhere in there can anyone claim that a 17-year-old cannot possess a rifle in public. Now, it's not true that the judge ruled that he could. He just simply refused to even bring it up because there was nothing in the statute that could be read that banned Kyle Rittenhouse from publicly carrying the rifle. To be convicted of a crime, you have to violate the law, and the law has to be clear on this matter. There was no law that Kyle violated. Therefore, the gun charge had to be dropped. So, sorry, you're wrong. The judge's decision to drop the charge was perfectly in line with the rule of lenity, which basically says that unless you can find a law that specifically bans an act, that act is not against the law, and you cannot be charged. Now, what about the pro-Kyle side? What about their whining and sniveling? Actually, they didn't. The judge ruled that Anthony Huber's past could not be used in the trial, and pro-Kyle said, yeah, that makes sense. They didn't complain, they didn't cry, they didn't bitch, and they didn't moan. And the same thing applied to Gage Grosskreuz's past and Jojo Rosenbaum's past. By the way, all of them very sordid. All of them would have really carried the day for Kyle, even if there had been any doubt. The judge did not allow any of that into the trial, and the pro-Kyles, being more mature and, well, a lot more intelligent and a lot more reasonable, all said, yeah, that makes sense. Kyle did not know about Jojo Rosenbaum's child raping, and therefore it made sense that the judge would not allow it. I didn't see any complaints about it. Maybe there were some, but for the most part, pro-Kyles took that in stride. So all of you anti-Schroeders out there, grow up. You know what? Grow up. The kid was acquitted. The judge was fair. Learn to cope a little better next time. Like my video, subscribe to my channel.